The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain family settlement agreements that are used in Illinois probate litigation and trust disputes. So first, let's talk about what a family settlement agreement is. It's an agreement between two or more beneficiaries of a trust or a will that have a genuine dispute over the meaning of a provision of the trust or will, and it's used to prevent litigation. So it can be used to adjust or clarify the provision of a trust or will that's ambiguous or where the intent of the creator of the trust or will is not clear. It has to be signed by all of the interested parties, but it doesn't have to be filed in court. And again, the general purpose is to avoid making the court interpret that provision, which requires costly litigation, as opposed to just coming up with an agreement as to how that provision should be read or adjusted to make it understandable. So let's talk about what a family settlement agreement can and can't resolve. When you think about traditional litigation, the parties to litigation can usually agree to almost anything in order to settle the litigation. Family settlement agreements are a little bit different because not only do you have to consider the wishes of the parties to the litigation, you also have to consider the wishes of the deceased person who created the will or trust. And for this reason, there's a limitation on what you can actually do with a family settlement agreement. You can't just use a family settlement agreement to circumvent the wishes of the person who created the will or trust. The only thing you can use it for is when the person's wishes are unclear or ambiguous. It's usually when there's poor drafting of the will or trust that leads to not a clear understanding as to how the executor or trustee should distribute assets or resolve any disputes. So if the executor or trustee is not sure about whether there's a genuine dispute over the intent of a provision of the will or trust, then rather than going forth with a family settlement agreement without filing it with the court, because you don't normally have to, the executor or trustee should take that agreement to court and get court approval of the family settlement agreement in order to protect him or herself from personal liability. Because just because the parties agree doesn't mean that it's a legally binding contract. That genuine dispute over the intent of the executor or trustee creates the consideration, the quid pro quo, that is necessary for a valid contract. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and you'll be notified of our daily article and video posts. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.